On every Tuesday from 5 p.m. to 6 p.m. Central Time, we do bring in the immigration updates that people who are in non-immigrant visas, who have not yet got the green card, they need to listen to ours. We update all things that are related to them. Emily, what do we have today?
All right, so we want to talk about the October Visa Bulletin.
Oops, is it already out?
Well, it's not yet, so we do have some time for that. So these are going to be what we may be able to predict for that, although we tell you all the time that we can never predict it accurately. We always get asked the question, so we'll give you some background on that. We also learned this week that there is not going to be a second lottery for the H-1B cap that happened this year. So we'll talk about what that means, why that occurred this way this year when last year there were 3 different rounds. We'll also give you an update on any important major immigration bills that are in the pipeline right now, what to expect with that, what are their chances. And lastly, kind of a unique situation that we've seen from time to time, but where a notice of intent to revoke has been issued on an H-1B because the actual wage was way higher than the wage that was listed on the LCA, like more than double. What is the cause of that, and what you should do to avoid that situation?
Emily, why can't you predict the visa bulletin? You've been practicing law now almost like 15, 20 years now.
Sorry.
Why can't you do it?
Yeah, it's a lack of data. I mean, we don't know with accuracy, number one, how many people are actually in the pipeline. We have all these I-140s out there. We don't know how many belong to the same person because a lot of people have multiple I-140s. We don't know how many family members they have. We don't know, as of this moment, we don't know how much spillover from family base is going to happen this year compared to the last 2 years, which was very beneficial to our clients. We may not see more of that. And we also don't know how many cases are currently in the inventory. How many will USCIS get to approve? Let's assume that they approve all 280,000 this year, which seems to be on track to happen. Did they take extra to where they're not going to be able to move the dates forward, which is kind of what happened in October 2021 when they ended up wasting all the green cards. They couldn't move the dates forward. So with all of that lack of data, it's truly anybody's guess what's going to happen. Do you think they could move forward? Could they even move backwards?
They can move forward, obviously. They can move backward also. Historically, that happened many times. It happened in 2007. When it moved back, it took a lot of time for it to become current again. In 2012, the May 1st, 2010 was the priority date, Emily, for the final action date, and it moved back in 2012, and it took 10 years for the priority date to become current. We did address on Sunday TV Asia, what if your priority date goes back, and if, what will happen to your 484 application? You can watch that. But a lot of people, anything can happen. As you said, data is not there. We don't have a lot of information there. They didn't release any information. We don't know how much spillover, if there is going to be any spillover from the family immigration. That's another aspect that we have. So it's going to be very hard to predict though. But if somebody is right now in 2015 priority date trying to think about jumping the jobs though, I definitely don't think so. They should wait at least until the October visa bulletin comes in, which is going to come in probably in about 3 to 4 weeks. It should be coming in. That's one thing. And there's also a lot of people are frustrated, Emily, what to do. My other applicants who filed in May 2022 are getting, I filed in October of 2020. I'm not getting my green card approval. They're very frustrated. And we do conduct a Zoom conference call every single day. Every week we've been conducting from past 10 years. And the link is provided at the bottom. If you want, you can attend, guys. And what I noticed, Emily, is that it's the people that are contacting multiple different sources. Ombudsmen, congressmen, service request, expedited request. All these things are actually causing a confusion in the immigration for them to move the file. So I'm suggesting that, look, if your application is in line, everything is in line, we recommend that you do not have to do anything. If you try to do too much, it's going to backfire on you at this point of time. The main things that I want people to do is that if their EB3 I140 is not approved, they should get it approved. If they have not filed the medical, they should interfile the medical. If their priority date is not current in EB3, if they have not refiled or interfiled, they should do it. And if interfiling does not the employer is not cooperative. That means that they moved to a different company and they're not willing to do interfiling help, though they can do self-interfile and try to chance to do that thing. Other than that, since the application is pending in line, a lot of people are asking, you have told us to contact the congressman so many times, contact the ombudsman. Why are you not telling to contact right now? Well, we have told you to contact when it is out of the line, though. We have told you to contact the congressman, ombudsman, and the USCIS chief that to contact only to have an administrative changes. For example, get these green cards approved. We have drafted the letters for you guys to contact the congressmen, senators, and all those people so that the 280,000 green cards get approved. But when it comes to the individual case, though, if it doesn't fall out of the line, though, and especially with all the people who are pending, everybody is contacting, though. What do you think so the officer will do it? Senator is calling, the ombudsman is calling, service request, expedited request is there, the file is going there. This guy has not called anything, did anything, everything looks cool. His medical is there, I-140 is approved, file the interfiling or does the self-filing, I'm going to adjudicate this case. And that's what is happening. We would suggest you anything what you can do to approve the case. We're not against you guys. We are in favor of you. We are the ones who drafted these letters. And a lot of people are saying, no, you're trying to restrict. No, we're not trying to restrict you. We'll be in a benefit when the green card is approved. If our own clients, when we file the green card, imagine, let's say they paid X amount of money for me to file a 485 application. If the green card gets approved in 2 months, guess what happened? That's it, my money is mine and I don't have to serve this guy in my life. He got the green card. Now, if I got the money and this guy did not get the green card, I have to keep answering these people for a long period of time until they get the green card, which is not what we want. Will be very beneficial. The guy who gets a green card 2 to 3 months, what is he going to do? He's going to recommend us. The next guy, we may charge a little bit more if things go on very smoothly. Definitely nothing wrong. People will be happy to pay. If the things are pending for 4.5, for a lot of years though, people are not happy. I mean, we know that. I've been there in adjustment of status for 1.5 to 2 years. I know how painful it is for everything. I have to go with an immigration lawyer. We want you to get the green card, but at this point of time, too much pushing is not recommended. You need to evaluate, is it good for you? Is it not good? If it's in the line, going through the normal process, don't do anything else. Anything else, Emily?
Nope, I think we're good on there. So next up is the H-1B lottery. So over the weekend, we started getting email notifications through our My USCIS accounts, just letting us know something has been updated. When we log in, we're starting to see notices change from submitted to not selected, but we didn't receive any update officially from USCIS until today. And today they did confirm that the cap has been reached based on the number of selections and the number of filings that generated in the first round. So they're not going to be doing a second round of the lottery. Why do you think this time around they aren't doing a second round when they had 3 last year?
Last year there was 3 rounds of lottery, and this time only 1 round of lottery. One thing, Emily, I believe is that they got educated a little bit more. Last time they picked less number of applicants because, as you know, Emily, that some of the people who apply in the lottery, they don't apply the application. So this time they evaluated it properly. Also, probably in 2021, Emily, they were just coming off the Trump administration. They expect, and they were still denying, and the denial rate was a little bit more higher though, compared to that of 2022. Now, Biden administration is there. They are going through the rule books. Things are looking much better, and things are looking much better. So the approval ratings are very high too this year. That's one of the reasons I think so that the USCIS has done a better job in picking the more number of people that they have adjudicated the application. That's the reason there's no number of lottery. A lot of people are asking, did they actually pick the numbers 65,000 plus 20,000? Yes, they did pick 65,000 and 20,000 that are going to be approved soon if they have not already been approved that much amount of time. There is not going to be any lottery, this second lottery this year, because they already confirmed it. Anything else, Emily, before we move to that?
Next up is what's going on with the latest immigration bills. We had some in the pipeline. where do we stand on that? So we have the EAGLE Act, we have the America Competes Act, we had the reconciliation process. Can you kind of give us an overview of each of those and where they stand?
Well, the EAGLE Act is right now pending in the Senate. It is being proposed by two senators. One senator is from North Carolina, Kramer. He's a Republican, and also Senator Hickenlooper, it's very hard for me to pronounce, is a very good senator from Colorado. He's a Democrat. It's a bipartisan proposal there. It has enough votes, Emily, in the House, especially Representative Lofgren from San Jose area. She's the she's a goddess of the business immigration. And she has, and since Democrats have the majority and they don't require any 60% voting there, it definitely is expected to pass. The hurdle seems to be in Senate. Most probably in about 2 to 3 weeks, we're going to put a letter where we'll tell the senators to contact. One of the reasons why this may not be the right time for contacting senators, I'm expecting this to move through Senate in the lame duck session. After the November elections are over, that means November 2022, before the January, that's when we are expecting it to move. That's when we're going to put out the draft letters for you guys to send it. So that's pending, but I want to go to the history of the legislation so that people understand the things, Emily. From 2016 to 2019, according to the data, now this is before COVID, Emily, the science and engineering graduates that were coming from India has decreased by 40%. Now, at the same time, between 2016 and 2019, the science and engineering went up in Canada for the student visa graduate student went up by 182% though. It's mostly thanks to the Trump policy. I would say that. That's the reason why a lot of these decline happened. We do have a different administration, but still we have stumbling back. H-1B is very hard to get it. Green card is very, very hard to get it, and there is no way out for them. We got ditched up in the U.S. Citizenship Act as Republican opposed the U.S. Citizenship Act. We got ditched in the American Competes Act, CHIP Act. House voted with the immigration provisions. When it comes to the Senate, though, Senator Grassley from Ohio opposed this legislation so that the immigration provisions never been put in, even though the America Compete Act, also called as CHIP Act, has passed. The immigration provisions are missing. Senator Grassley, this will be his last term. He is not contesting again. So hopefully we don't have to face him again. I mean, he was one of the, just like Joe Lofgren is the best congressman that I say that is available for the business immigration. Senator Grassley is probably, he hates legal immigration. He hates Indians. He hates IT people. I don't know how to say. He hates Indians too. So he's not going to be there in the Senate coming. So hopefully we may have a better session. We also got ditched in the budget reconciliation bill, which went through Senate and House, but because the parliamentarian opposed it, they didn't put the immigration provisions in there. And Senator Durbin from Illinois, Senator Mondays from New Jersey, did not support us in this particular bill. If both of those people would have supported, we would have the immigration provisions in the budget reconciliation bill. The people in the Congress, I don't know what kind of people they are in. There are some good people, Joe Lofgren and other people that are definitely, especially in the House, we have a very good people though. But if the people in the Congress are not going to support the PhDs in science and engineering to get the green card, I don't know what kind of Congress we have at this point of time. I pity these people though. While the jobs are moving outside the country and we have a chip shortage, software professional shortage, it's definitely not a good thing though. Let's hope the EAGLE Act, which removes the per country quota limit, and also similar provisions which Joe Lofgren from House is promoting, will get through. But we will try to promote this somewhere in October to January. That's a time where we need to fight on. In the meantime, what we want you to suggest to the House and Congressmen, and which from the next week we are going to enforce it, that we're going to try to see if you would send that letter, that particular letter to the administration where we put it down. The letter that where we put it in the YouTube is that send it to the administration, recommending them not to count the family members. Remember, in H-1B, we have 65,000 plus 20,000. They don't count the family members. Why are they counting the family members in the business immigration? We have only given 140,000. Out of the million green cards, only 14% are allocated to the employment based. In that, we have a per country limit. In that, they are counting the family members. If the administration, look, we have to tell this administration, Democrats, you may be in favor of immigration, but you can't get a bill passed in the Senate. You cannot get it over it. There are some things administration can do. There are some things administration can do while the Congress is, or the Senate is not passing anything. The thing what they can do is that stop counting the family members. Utilize the green cards that they have wasted. The administration has an authority to do so. So these are the steps. We put a letter there for you guys. This is not the same letter where we are telling people to use the 280,000 green cards, which you all supported. You all wrote the letters and the administration really acted on it. I mean, they really acted on it. They have tweeted, they have done it. I mean, we are expecting at least to reach 280,000 green cards, if not very close. This other letter is not counting the family members, using the unused green cards from 1992 that have been wasted to right now. That will clear up the backlog. We have put a draft of it. We have put a draft of it from law. Next week onwards, though, what we are going to enforce is that if you have written the letter, we will try to answer those people. Anything else, Emily?
Yeah, and with the not counting the family members, there's statutory support for that. The way that the statute is drafted for family-based immigration versus employment-based immigration is different in the exact wording that they used and how they structured the legal statements there, but they're treating them exactly the same in terms of counting family members. And so that is something that it's the law that's on the books in terms of this is what Congress has passed, and it's the administration's interpretation of that law that could be changed and still be complying with the law. That's why we can do this without having to go through Congress, because again, Congress can't seem to get anything done. So definitely we need to start pushing on that, as well as once we get into the lame duck session, trying to push some of these immigration bills.
Emily, with regards to working for multiple companies on H-1B, you have said so many times that people can work for multiple companies at the same time. But yet we got a notice of intent to revoke where the salary is 100,000 on the LCA, but they actually are getting paid 200,000 in the paycheck. What is that for? How do we avoid that?
Yeah, so the problem is when you're making way more than what was listed on your LCA, the officer may be thinking maybe this person is doing a different job than what's listed on the LCA. So on the LCA, we have to set forth what the job title is and what occupation code that falls under, as well as what wage level it falls under. So if you're making double what's on your LCA, maybe the wrong wage level was selected and you misrepresented that job description in the petition compared to what you're actually doing. And that can be seen as harming US workers because they're thinking that this job only pays 100,000 when in fact it pays 200,000. They may have applied for that job and gotten it. So that's kind of where the issue is. And is this a situation where the person's actually working for multiple employers, or they're working for one employer?
Let me take back. Actually, he's working for one employer, Emily, but two clients.
Okay, so he's kind of doing double the work.
Yeah.
And maybe this happened after the H-1B petition
was
filed and doing the exact same work, but kind of working twice as hard.
That's right.
Or maybe being able to do that within a 40-hour week.
Right.
Yeah, so I think there's nothing inherently wrong in that, but the issue that's raised when there's such a big discrepancy is, did the company misrepresent this job on the LCA and in the H-1B petition? So if you are going to be taking on extra work, it's very common in any industry that you be paid extra for that. It may be a better option to do that in the form of a bonus for your additional work that you've put in, because obviously if you're a salaried employee, when you're a salaried employee and on the LCA it's listed as a salaried position, you are supposed to be paid the exact same amount every single pay period, never more, never less. Now, if they want to pay more because you're doing additional work for a short period of time, you've got additional projects, that can be done as a bonus, but generally these bonuses are not going to appear on every single payroll, and the bonus does appear separately in your wage report compared to your regular wages. So you do need to make sure that that gets separated out. You don't want your actual base salary to be going up and down month to month or being anything different than what's on your H-1B petition, unless of course it's based on a promotion, normal career progression. Yes, your wage can increase over time and it be different than what's on your LCA, but in this situation we're talking wages being double what's listed on the LCA. That can be a red flag, so be careful how that pay is worked out. To make sure that you are clear that you're doing the exact same position, the work has not changed, you're just taking on additional work, and that's the reason for these additional payments.
Questions that are coming from Atul from YouTube is asking the question, can the Biden administration not count the family members by an executive order? Absolutely, he can do so. He can do so by regulation, he can do so by executive order. He can do so just by issuing a memo from the administration that, well, from now onwards, we're not going to start counting, there's something wrong. They can always issue a memo and stop counting the family members. Believe us, that is going to make a lot of difference. From 140,000, we're going to move to almost 300,000 green cards, because not only family members are just spouse, but also children are there too. So definitely that is going to bring down the waiting period for all the people who are waiting for the green card. And that letter is drafted there for you guys to do it. You should write the letter. Going forward, we will address the issues of the legislation, because this is not the right time. We're going to try to address that at a later date.
Ananda from Facebook says, why are perms taking so long? It's been 8+ months to process. My priority date is current. What to do? Yeah, that is a continuing problem that we're facing, and unfortunately there isn't anything to do but to wait for it, because you need that to be able to file the I-140 and 485. And the Department of Labor does mostly follow first in, first out. They do not expedite any perm for any reason ever. They never have, they never will. Why are they taking so long? It's a combination of factors. A lot of it goes back to October 2020 when the Trump administration changed how the prevailing wages were calculated. DOL got a huge increase in prevailing wage requests right before that was going to take effect, so they had a lot more of those to do. And then after that rule got eliminated, they had to go back and reissue a whole bunch of prevailing wages that they had issued during that time. So they got behind due to that. And then of course, COVID, I'm sure, is playing a factor. They have limited resources. They are not fee funded. That means that they have a set budget and they cannot exceed that budget. They don't get extra money based on the extra filings that they're getting. Everybody who jumped employers right before October 2020 all of a sudden needed their perm to be filed right away. So the number of perms that have been filing continues to go up. All of that is compounding these processing times. Doesn't look like there's any plans to try to improve those at this point, and there's not anything to be done at this point either.
Arun is asking a question from YouTube. His priority date is February 12, 2015. When can I get the green card? Obviously, you didn't file the 485 application as your priority date was never current. Instead of guessing to do somebody doing something for you, we doing something, some star is going to fall down and you'll get $1 million. Let's try to, Arun, I want you to proactively write a letter to the administration telling them not to count the family members. I can assure you one thing, Arun. If they stop counting the family members, your priority date will be immediately current. I assure you that. You do that one. And every friend that you find out, you have them write the letter. You don't enter to any friend's family friend who does not write the letter, because we consider that guy as, he's deceiving the employment-based green card. We need IT workers like you, Arun. They need to write the letters. To have them write the letters that we put in there. That's a step that you can do. Now, we made everybody write a letter to have the 280,000 green cards to use that. People laughed at us. Rahul, you tell us to do so many things. We did so many things. Nothing ever gets happen. Guess what? The 280,000 green cards got happen. Now, we are not telling that everything we told when we wrote the letters, it happened, but there are some times that happens. And if you, Arun, can take over, you take over the leadership, you have everybody write a letter, you enforce against us also. Hey, Rahul, don't answer the question unless they wrote the letters that no, family members should not be counted. You enforce on us too, okay? Then we can achieve it together. So that I assure you, if the family members are not counted, you date will be current.
S. Reddy says, should I get the medical done now or wait? My priority date is April 2015. We generally recommend waiting until you know your priority date is current. You generally have that 2-week advance notice before when the visa bulletin comes out, plus you have the entire month to file the 485. Because once you get the signed medical, it's only good for 60 days. So if your date doesn't become current within those 60 days, you're going to have to get it done again. So we don't want you wasting time and effort on that until we know for sure.
Arun, people are asking, a lot of people are getting interview letters for the 485 application. I want to answer some of the questions though. Is it something you have to be worried about? No, I don't think so you should be worried about. You should take this as an opportunity to get the green card as fast as possible. What are the things that people need to take care of? One thing I suggest is you can take a lawyer to the 485 interview. Will the lawyer will be answering the question on behalf of you? Most probably not. If it's only some legal matters, we'll interview. If you don't want to take the lawyer, most of the people don't take the lawyer. You can have a lawyer present through phone also, that's available too. The second option is that, which we normally suggest for sure, is that to have a mock interview done by a lawyer. In our office, we normally, what we tell is that we give them the list of questions, what people ask, we give them, there is a AOS interview that I think so, Emily or Revoke has presented it. We want you to go over that one. And we also will give a list of documents. And I normally, in our office, we do a mock interview. You know, going through from the beginning, when you enter, have you raise your hand, you're going to tell nothing but the truth, and you're going to tell the truth. And from there onwards, we're going to go as a mock interview though. It may be better for you to prepare for that one. A couple of other people were asking question. I only got the interview, but my spouse and children does not get the interview. What do I do? I recommend you take them with you. You try to take them with you. When you go into the security, you show them the interview notice. They may allow your spouse and child to come in without the interview notice. They may not allow. If they don't allow, tell your spouse to wait outside in the car. You know, it's not that cold right now, and then can put an AC there and stay there. Or they can stay in a nearby Starbucks or someplace like that. So that you attend, if needed, the officer can call your spouse and child to come for the interview. Maybe they missed out. I don't want to take any chances. You take them for the interview. So mock interview is the best thing. Don't take that. If you get an interview notice, don't cry about it. Oh, I got an interview. The other person did not get an interview. No, this is an occasion for you to get a green card before September 30th. So take that and prepare well before you go for the interview. In the past 2 to 3 weeks, though, we have received a lot of interview notices. At the same time, we received tons of green card approvals, though. There's absolutely no doubt. They are going towards the 280,000 green cards. So definitely take this as an occasion interview that you have a better chance of getting the green card than compared to the people who are not getting the interview call.
Sanjeev says, are there any more visa numbers available at this very moment? We see slow movements. They are currently available. When they become unavailable, assuming that they run out of the 280,000 before September 30th, they will announce that and make an update in the visa bulletin and change that category to U for unavailable. So we don't expect that to happen until September. We don't know exactly when in September. It may not happen at all if they spread these out enough so that they don't utilize them up before September 30th. But at this point, yes, they're still available until we find out they're not.
Emily, the September visa bulletin has already been issued. can they reissue the visa bulletin and tell that it's not available at all?
Yes, absolutely. They have done that in the past, and they did warn us that that's a possibility in the September bulletin.
Yes, and when they do that, though, they may come on September 10th, September 5th, or September 15th. They will put unavailable U in that particular column. That means that from then onwards, they are not going to grant any more green cards going forward. Having said that, if they have already allocated the visa numbers, though, they can still grant the green cards, though. We have noticed last year when the priority date has been current for EB3 and then later on it was not current, the visa numbers for some of the people were been allocated, they granted the green card. So even if it goes back, if your visa number is allocated, you can still get the green card. But most probably though, yeah, you won't get it. Now that's only until October. Now from October, the visa bulletin will be different.
Chaitanya says he spoke with InfoPass and they said his case was transferred to the Denver field office and he hasn't sent the medicals yet. He wants to know, can I send the medical interfile directly to the field office or should I wait for the medical RFE? Yeah, I don't see any downside to doing that because by the time the officer actually opens up your file, if those medicals magically appear in it, that can avoid an RFE, which can delay the case by a month or two. So absolutely no problem with doing that. It may not work, but you're no worse off than you are now if you go ahead and try.
I would recommend when you're getting the medicals, try to get the medicals from a doctor to get 2 original medicals. So just in case, so you send it to him, then the RFE comes in back. I still want you to respond to the RFE with the medicals. I don't want to rely on it. Submit the medicals.
Siva says, does USCIS send all the RFEs for the 485 together or can they send one after another? Do you see any other RFEs that happen after a medical? So they generally do review the application in full first and send one RFE requesting everything they need, including the medical if that is missing. From time to time, they might have missed something and send a follow-up RFE for something else, but that's pretty rare. I would say 99% of the time, they send everything in one RFE. So if you're getting an RFE just for the medical, that means they've reviewed everything else and are not requiring anything else.
Astik Ahmed asked, Subbu has a question. Sorry, good. Too many things that are getting in. Mohan actually, sorry. Mohan is asking, do you have a template of letter not counting the family members and to whom to write? Yes, Mohan, it's there down in the link. In Facebook and in YouTube, it's there. Now there are 2 letters. So one is to get the 280,000 green cards, that's one letter. There's another letter is not counting the family members. So please go through the letter and you will be able to draft. I mean, it's already there. You just need to make some modifications. We definitely want to emphasize more since 280,000 green cards are getting out, and then we may not have a spillover next year. We may have a spillover, but if they stop counting the family members, I mean, that is going to be heaven for you guys. Believe us, it is going to be good for you.
Madhav says, can I apply for the 485 based on an old employer's I-140 approval through a new employer when the dates are current? No, that's not an option. So the only way you can file the I-485 is if the old employer is going to offer you that same job that you were sponsored for on that labor certification and you intend to go back to work for that old employer. If you're going to be filing through your new employer, the new employer must have a new labor certification and new I-140 for you to be able to file the 485.
Dr. Krishna has this question. He's EB3 for it. His EB3 priority is April 2015. Do you suggest applying in EB2? Definitely. I want both the options available for you. For the people who have EB2 though, they automatically have EB3 as long as the employer is cooperative. They have the automatic. But if the labor certification is filed in EB3, you may not be eligible to file with using the same labor certification to get an EB2. So you need to file another EB2. I want you to have both the options available for you.
Anshuman says, my 485 was filed May 1st, 2022. It's at the National Benefit Center. Biometrics were done in June. Should I expect to receive the EAD and AP before the end of this fiscal year? Potentially not. I mean, if your case is ready to adjudicate, before the end of the fiscal year, which USCIS said they were trying to do, you would directly get the green card and not get an EAD and AP at all. Now, if they don't adjudicate it by September 30th, then likely they are going to issue the EAD and AP because they're going to take their time with the 485 because they have a whole another year to process it. But the EAD APs are still taking 8 months, 8, 9, 10 months. So it's I would not expect to get that before September 30th.
Before we go any further, we are receiving a lot of messages, sweets, champagnes. Guys, please don't.
I kind of like it.
we suggest that you write the letters. We write the letters to the administration to not count the family members. That is the best favor that you can do. That is going to buy us a lot more sweets. Don't worry about it. We'll make a lot more money. And you guys, when you guys get the fast green card, we get a lot of money. Believe us, we make money. I mean, nothing wrong with it. But yeah, please, there are a lot of contacts. People are calling, emailing. Thank you very much. We like you calling, but we want you to write the letter. Now, since you got the green card, we want you to help the people who are coming up. Please go to that letter that we have put in there. Write that letter if you have not already written. Even though it says that you are in the line, just make some modification in it and get. Emily wants it. That's fine. Sweets to green card, sweets and champagne for her. I am becoming fat.
Manohar says, my GC got approved 2 months ago. My spouse's GC is still pending. Raised a service request. USCIS replied that they should approve it within 90 days, and it's been 60 days. What do I need to do? Unfortunately, I don't think there's anything I would do at this point. They are working on them. We are seeing this from time to time. It's more common than it used to be that the spouse gets separated, but they just need to take the time to actually get to it, and continuing to follow up is likely to slow it down. So I would not take any action at this time, except for possibly litigation would be the next step.
Shiva is asking the question. EB2 refiled, medical RFE says to withdraw the EB3 I140. Is that common? How to respond? Shiva, that used to be very common procedure before, especially when we were dealing with Chinese nationals though. They used to, when EB3 and EB2 was pending, they used to request, which one you want to go? Do you want to withdraw EB3? Then when we withdraw the EB3, they used to approve the 485 for EB2 though. In your case, I definitely will withdraw EB3 now. That's only in your case, Shiva. I am not telling for all the people where EB2 and EB3 is pending, because most of the time they are not issuing any, they are not requesting to withdraw EB3. They are just directly approving the EB2 and they are denying the EB3, which is fine because you already got the green card. You don't need EB3 anymore. But in your case, the officer did a little bit differently. I want you to go with what officer wants you. If I were your lawyer, if I were you, I would send the withdrawal letter, the I-485. 99% of the time, your green card will be approved immediately. And I want you to do that as soon as possible.
Kumar says, I reapplied for the I-140 with a previously approved perm from 2013. How long is it taking for the I-140 receipt and regular processing? And how long do I need to wait to upgrade to premium after the receipt notice? I would say receipts are taking between 2 and 4 weeks, and you can always check to see if the filing fee check has cashed if you have not received the receipt yet, and you may be able to get the receipt number from the back of the check, and that would allow you to do that upgrade. I would do the upgrade as soon as you have the receipt number. We've not faced a lot of problems with that like we were going back to the October 2020 cases. They've been pretty good about processing the upgrade as soon as we have the receipt.
Istak Ahmed says that his prediction is 30 to 50,000 green cards might be spillover in the fiscal year. Hopefully so. If they do, will there be a movement? We don't know, Istak, if that 30 to 50K, because remember, we are right now in the month of August. We still have 1 month left for the family immigration. Family immigration mostly happens in the consulate though, especially the preference categories though. We have noticed a very uptick with regards to the appointments and granting the green cards for the family immigration. So we don't know if it's going to be 30 to 50K. Even if the 30 to 50K will come in, we cannot estimate if the priority date is going to move. Because remember, for Indian nationals though, if they have a lot more applications left out for Indian nationals still there, The problem is that when we have the spillover, they may not move that forward though. But I hope you're right. I hope the priority date moves. I hope they don't even count the family members. That's even much better for me. But everything is up in the air, as Emily has pointed out in the first 5 minutes of this video, that why we cannot predict the priority date, why nobody can predict the priority date, why even the State Department and the USCIS cannot predict the priority date, because there is 1 month time. We don't know how much the State Department, that means when I say State Department, it's the consulate are going to approve the green card though. So there are many multiple factors that are in there to estimate with the priority date, and that's the reason, even though we put the title, what the prediction for the October of visa bulletin, we couldn't come up with any logical answer though.
Soon says, can I renew my EB3 EAD after interfiling to EB2? Yes, you can. So when you're interfiling, there's only one 485, and that's all you need to renew an EAD is a pending 485. It doesn't matter if it's an EB3 or EB2 or halfway in between. As the interfile is in process, you can renew that EAD.
A lot of predictions about the priority date, which are tough, guys. We do understand, how tense you are. Believe me, when I filed my 485, it was current. When I got my green card, actually, I correct myself up. It was May of 1996, I got the green card. We already got the visa bulletin that in June, the dates were going back. So if I wouldn't have got the green card in May of 1996, I would have been stuck there for 3 to 4 years at that point of time. This is in 1996 I'm speaking about. You can go back and look into the Indian Nationals EB3 preference at that point of time though, for you to look into May 1996 to June 1996. We do understand the pain, but it's very hard for us to predict the priority dates. That's the reason we come up with it, is that you take the things in your hand. Don't give it to USCIS, don't give it to State Department, don't give it to us. You take it, we have drafted it, and if you need any help, you form organizations, you form the groups. We will be there, we will assist you in doing any technical work. We don't want the USCIS to count the family members. They shouldn't have been counted at all. We want the not wasted green card from 1992 to 2003. All wasted green cards should be used up. Please have the USCIS do that. Take it in your hands. That's all you can do right now. Predicting the priority date is like, parrot pulling out a card. You remember those guys back in India? The parrot comes out from the cage and puts out. Believe me one thing, that the parrot will be better than me and Emily in predicting the priority date. So I want you guys not to believe in these parrots, okay? And we are worse than parrots in predicting the priority date. We want you to take it, write the letter that's in there.
All right, Chan received his EAD and AP and wants to know, what is the procedure to switch to the EAD? There actually is not any procedure you have to follow. It kind of just happens in the air. It's in your head. There's nothing that you have to do. You don't inform USCIS. You just stop using your H-1B or your L-1 or whatever your underlying status is and start using your EAD the next day. Now, if you're changing employers, you would show your new employer the EAD card for your work authorization instead of providing the H-1B and going through all the transfer process. For your existing employer, they may or may not have you update the I-9 for the re-verification process, because they technically don't need to do that until your current work authorization expires. At that time, then, if you don't have your green card yet, they're asking you to re-verify. You can provide them your EAD at that point, but you can consider yourself to be using the EAD all along. It's all kind of in your head.
Motion has received an RFE for medical, but he did not interfile to EB2. Should I do that interfile right now? Yes, right now do it. Don't delay it, do it. You want to get the green card before September 30th, do it. Chintan has this question. Can we expedite the H4 and H4 EAD process? Chintan, there is a better process that we have invented. It's called Margarita H4 extension. It's called 540 days. Just type in the YouTube 540 days H4 and Reddy Neumann. You will have an article. There are ways where you can get the EAD extended by 540 days by visiting Mexico if you meet all the requirements in there though. Or you can have a consultation though. Because everybody asks for expedited, then the USCIS won't follow those things. There is 1% of the time they do expedite, and we don't know when that 1% is. So if you go with our policy though, you have a chance of 98% success rate where your EAD can be extended by 540 days. Believe us, we have the technique.
Nico says, are they giving any priority for Schedule A employees during the 485 adjudication? Unfortunately, no. So Schedule A is for physical therapists and nurses. It's kind of a somewhat fast-track green card in that you get to skip the labor certification, but beyond that, the processing is exactly the same as any other EB2 or EB3 filing.
M1234, how to make an officer aware of cross-chargeability. Is a cover letter enough? I normally put a color sheet. Do not reject in the mail room. Refer it to the supervising officer before they reject. The reason is that, I just want to explain what a cross-chargeability is. Let's say, for example, this gentleman is born in India and his wife is born in Dubai. Even though she's not a Dubai UAE citizen, they come under the cross-chargeability section though. So when he's presenting that, saying that his wife is born in Dubai, they ignore those things when you put in the cover letter though, because they look into your country of birth, your citizenship, boom, you are from India, you're gone. So I normally put cross-country chargeability. Do not reject in the mail room. Refer it to the supervisor. So what happens is that when this mailman comes in, he opens it up. These are the people who deliver pizzas that are working in the USCIS. Believe me, I've seen them. And they have no knowledge about it. They look into priority date, Indian, not current, they're going to reject it. So when you put the color sheet though, you're telling the officer, you're telling that contract worker, not an officer there, is that, hey, there's something wrong. This lawyer is writing saying that, oh, do not reject. So he must already know there is something wrong. Let me call the supervisor. They raise a hand, the supervisor will come and look into it, and then they will input it. So please do that.
SR says, I don't have the birth certificate. Is it okay if we get 2 affidavits from friends who reside in the US? So when you don't have the birth certificate, you do need to get a non-availability certificate from your state in your home country first, and then you can support that with 2 affidavits. They can be from people who are in the US. They just need to be people who are familiar with you and your family and the details of your birth. And then in addition, you need to provide secondary evidence that supports the affidavits. That could be in the form of hospital records, school leaving certificates, anything that has your name and birth date on it that's as old as possible. So all of that combined is what you would need to be able to receive the green card when you don't have a birth certificate. You don't necessarily need all of that in order to file the 485. So if you're having trouble getting the non-availability certificate, you can file without it, and then you'll get an RFE asking for it later.
Boss, as his question, I received a medical RFE for both, but responded in one envelope to Tampa field office on August 10th. No updates yet. What do you advise, please? Well, we normally advise, if you get an RFE for medicals for both the people, we tell them to put in one envelope. That is our advice though. You did very good job. It's August 10th right now. My advice to it is that do nothing. Do nothing. Everything is going in line. It's about to be approved. You don't want to be put out of the line. That's my advice.
Ilan says that interfile was done with the notice date of July 15th while the EB3 I140 was still pending, but since that time it got upgraded to premium and has been approved. Any issue with this sequence of action? Case is not picked yet. So no, that's fine. No issue with the timing of that. The most important thing is having both I-140s approved and having the interfile done. The last thing you can do is submit your medical if you haven't done that yet. Beyond that, it's just a matter of time, so you just need to wait.
After the perm is approved, what is the pros and cons of concurrently filing I-140 and 485? We normally tell people to get the premium processing approved I-140 to file I-485, but I don't know if I would tell the same thing. If you would have contacted me in May and June, I would have definitely told that. Right now, we are coming to the end of September of 2022. It's very hard. What do you say?
Yeah, I'm still leaning towards the separate filing, mainly because I don't want the 485 to get stuck in Texas or Nebraska for any length of time.
Yeah, but maybe you're right. Yeah.
Yeah, so the biggest thing would be make sure that the date is going to remain current, so that by the time you do get your I-140 approved, you still have the chance to file your 485. If you get any kind of advance notification that your date is going to not be current, then hurry up and file the 485 before that happens.
Rakesh Kuchampalli. My file has moved to field office. Yay! What does it mean? Visa number is allocated? No, we cannot tell that the visa number is allocated, but I can tell that things are going very smooth. If I were you, I will buy a champagne, put it in the refrigerator, be ready to open it. Questions that are coming up straight. EB2 filed in May 12th, 2022. Fingerprints applied. We put fingerprints applied in 6/6/2022. Everything looks to be going very smooth, Rajgopal. We don't want you to do anything. There are cases that were being filed afterwards that got approved. I know that, but at this point of time, our advice is not to do anything.
Apur says, is there any way to get help in getting SAVE expedited? DPS says it's over 26 business days for processing, which makes no sense since the I-797 has been approved by USCIS, and they're just going back to them to get that verification. So what is this all about? So SAVE is the system that a lot of benefits granting agencies use in order to verify your immigration documents before they give you that benefit. So the best example of that is your driver's license. So if your state uses the SAVE system, that means when you walk in to get your driver's license or renew your driver's license, you're going to bring all of your documentation. Even if you have the original I-797 approval notice with the original I-94 on it, everything looks perfect. They are not going to accept that by itself. They're going to go put it into the SAVE system. The SAVE system is going to reach out to USCIS and ask them, hey, is this a valid document? Does this person have status? Can I issue them the driver's license? USCIS responds back in the SAVE system, letting them know everything's clear. And then they contact you and tell you, okay, we can give you the driver's license now. That's kind of the process for most states these days, and as far as I'm aware, there's no way to speed it up. Everything just got into trouble because of COVID. A lot of the driver's license offices were closed. They have these pending backlogs, and yeah, it's a mess. And for some people, it takes months to get that done. I've not found a way to solve that problem yet, and it does seem to be getting worse. And that's kind of just where we're at. Just keep checking. You do have the option of checking the SAVE system yourself to see what the status is. It will eventually show approved and sent back to the benefits granting agency. Once you have that message, then you can take that to the driver's license office and ask them to issue you the driver's license.
Sriraj Kadapurakal has this question. My date of birth and birth certificate is different than that one on passport. Will I face an issue with green card processing? Yes, you will. It's better that you contact a lawyer. I would suggest I may be the right person because I'm also a lawyer in India too. One thing is that the USCIS is very strict. If there is a wrong date of birth, you'll be gone. They won't issue the green card though. You can't get a non-availability certificate if the birth date is, if you have the birth certificate. So I want to know which is the birth date though. If the birth date is on the passport, you can go to the court system in India and correct it in the birth certificate. Now, if the birth certificate is right, can you change all over? I know your 10th grade certificate is the same as passport. I know your school living certificate is the same as a passport. I know your I-94, your H4, H1, whatever not, is all according to passport. Can you change everywhere? Yes, you can. There are ways. First, you can go to the consulate and change the passport. From then onwards, when you renew the H1B or H4, you can change it. And at that time, if anybody asks a question, you can write an affidavit. Look, I thought this was the right date of birth until I found out in the date of birth that my date of birth is wrong. Now, this is very tough for the civil law country people to understand it, though, especially, countries like Spain, Mexico, they're all civil law countries, though, but especially common law countries, these are easy. And though US is a common law country, though, when it comes to the birth certificate, maybe the officers are mostly from Mexican background. They think it that way, but there are ways to get it corrected. And we have seen 485 is denied because of that. So you can correct passport and everywhere, H1B and other things. It's not that difficult to correct it because the consulates will go with the birth certificate and they will correct it in the passport. Then you can go and correct it in the H1B. Then you can go and correct it in the Social Security. Then you can go and correct it everywhere you can. And will that be considered as a misrepresentation? No. We have never seen the USCIS or Department of State considered as misrepresentation. We have had very many success cases where we changed from everywhere, we changed the date of birth.
COS says, my Indian birth certificate is in my native language. Does it need to be translated into English and notarized? And what's the best way to do that? Yes, so when you're filing your 485, any document or any H1B, anything you're filing with USCIS, if it's in a foreign language, it does need to be translated. It does not need to be notarized. So you can have a family member or a friend, anyone who's familiar with both languages can make the translation, and then they have to sign a certificate of translation accuracy, but it's not notarized. It's just a certification that they're stating that I certify that I'm familiar with both languages and I have translated this to the best of my ability. And they sign that. That is all you need. Again, it can be a family member, it can be a friend. You don't have to go through a translation service for that. You can if you want to, but not required.
Srinu from YouTube is asking, what is a dial-in number to call for this show and ask the question? Unfortunately, we don't have the dial-in number, Srinu, but we do have a daily conference call every single day from 2012 to right now, from past 10 years. Reddy Neumann PC has been offering free conference call to ask general questions from 2012 to right now, straight 10 years, every single day. There is a link there for you where you can go there. Their timings are Monday at 3:30 and Mondays and Fridays at 3:30 p.m. Central Time, Tuesdays and Thursdays at 11:30 p.m. Central Time, and on Wednesdays at 4:30 Central Time. We have a link that is provided there. We do have a Zoom where you can personally ask questions at the time, because in this one we don't allow phone calls or Zoom sessions. This is are the questions that you post, we answer.
JJ says, if my employer starts the green card process today, how many years, as per the current average, can I expect to reach the 485 stage? That's a great question. Depends on a couple of things, but let's assume that you are, EB2, EB3, basic perm-based filing. So the first answer is you can expect it to take 18 to 24 months for you to get to the point where you have an approved I-140. Now, beyond that, when you can file the 485 is going to depend on your country of birth. If you're from a backlogged country like India, you could maybe take 80 to 100 years.
Unless they stop counting the family members.
Yeah, so that is the calculations that we did a couple of years ago. I think I had originally said 80 some years, and then the Cato Institute came out.
You are wrong by 40 years.
Yeah, it was more than 100 years what they came out with, and that's just based on how we're seeing these dates crawl, how many people are actually in the pipeline. Again, we don't know exactly because some people do have multiple I-140s. It's very difficult to tell exactly who's EB2, who's EB3, and how many family members each person has. But doing the best calculations we can with the data we have, it could be decades before you can file your 485.
That's the reason we want you to write the letter, not counting the family members, then it'll be much easier. Nihit has this question. Is the 485 is getting adjudicated in Nebraska at all? No. Answer is simply no. Now, of course, they say that if it's already opened and they're already working on it, they will adjudicate it. I haven't seen anything coming from past 3 months. So absolutely no. Anything else, Sandy?
I think we're out of time for today. Thanks so much for joining us. Please get those letters written. That is going to be your best way going forward to deal with these priority dates, no matter what happens in October. And don't forget, you can subscribe to our newsletter by going to rnlawgroup.com so you can get the latest updates every Wednesday.
Thank you very much.